I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are continuing our series on building the AI lawyer skill set with a discussion of AI, export controls, and international trade law. As listeners of this podcast know, AI lawyers seemingly need to know a lot about a lot. AI impacts almost all areas of law, which makes practicing AI law difficult. Whether it's IP, privacy, antitrust, cyber, transactions, there is so much to know and so many issues to spot. The Data Chronicles podcast is here to help with this special AI mastery course that includes episodes that cover the many legal issues that AI is raising and how you can help spot issues across legal disciplines. Today, we focus on export control and international trade law, for which I have invited my partners, Aline, Doussin, and Stephen Propst, to the podcast. Together, Aline and Stephen have both sides of the Atlantic covered, the US, UK, EU, and regularly advise multinational companies on how to develop and sell AI-enabled products on an international scale, while managing the many legal issues that AI is creating and presenting under trade, export, and national security laws. Aline, Stephen, thanks so much for joining the podcast. Stephen, maybe I can ask you to get us started. If you can maybe help give me an overview about how you're seeing AI issues present in the context of export control laws and the various issues that AI is creating in that space. Would love to hear your perspective.
Sure. So concerns about the rapid advancement of artificial intelligence has been sort of a key focus of US export controls developments over the last couple of years. AI combined with a few other areas, related areas of emerging technologies, such as advanced semiconductors and supercomputing, have really been the focus of a number of very large and important regulatory developments over the last couple of years. And it's really being driven by the broader US foreign policy and national security concerns related primarily to China, but also to other adversaries like Russia and Iran, where there are increasingly concerns about the potential use of artificial intelligence to develop and support advanced weapon systems that can threaten US national security.
Yeah, I mean, interesting. Aline, I'm interested in your perspective on this too. Is it the issue where this is starting to pop around the export of artificial intelligence technology itself? Or is the issue around the ability of using artificial intelligence capabilities to create different types of weapon systems or different issues itself, not as a result of the export of the AI, but more importantly, just the use of the technology that would support the development of those competing weapon programs?
Yes, exactly. Thank you, Scott. I think it's clearly more sort of the latter, because I don't think we are looking at sort of the regulating the export as such as yet, because AI is developing as we speak. I mean, we are looking more sort of how do we address the regulation of AI in its development and research and development stage, I guess, perhaps most immediately. But perhaps is worth bearing in mind is export control in itself looks at regulating sort of the export, but also the supply, the transfer of specific goods, software, and technology that can be used for both civilian and military applications. And clearly, when you think about AI in itself is a dual-use technology, right? Because even if, in most instances, it will be used for completely civilian and innocent sort of application, it might be that in some specific instances, it can have a prohibited end use and something that's specific, and an end use that specific governments would want to prohibit prior to their export to those countries, or even their ability to be accessed by specific end users or specific governments.
Yeah, I mean, interesting. Stephen, maybe from your perspective, and one theme of this series that I think is evident to listeners is that, AI can be a difficult area to understand what the legal systems and legal frameworks that apply, because while most folks would want to advance forward, say, well, what is the AI law? We're really in the position where we don't have a lot of AI specific laws at this moment. There are some that are emerging, but more importantly, it's just that AI is being regulated under existing legal frameworks. And so I'm interested in your perspective. What are the existing legal frameworks that relate to export control that you think are now uniquely being applied to AI? Let's start in the US, and then Aline, interested in your perspective from the UK and EU.
Yeah, Scott, I think that's right. On the US side, the US government really is looking at a pretty comprehensive web of tools to regulate all aspects of AI and the use of AI for military purposes. And again, really sort of across the board, trying to limit the ability of adversaries like China from developing AI capabilities and using them for military and intelligence purposes. And so the challenge they faced, as Aline mentioned, is just that, the building blocks for AI are largely commercial dual use, mass market technologies that have very broad commercial applications and are expected to drive a very large growth economy over the next few years. And so the challenge has been how to implement targeted controls that address the national security and foreign policy concerns without unduly inhibiting commercial innovation, and also putting US companies at a disadvantage relative to their international competitors. And so this has been a real sort of policy challenge for the US government and a number of the agencies. But starting with sort of where we are today, there's a base of existing controls that weren't really specific to AI, but that apply to these emerging technologies already. And those are restrictions, including the international traffic in arms regulations that prohibit exports or impose licensing requirements on exports of all sorts of hardware, software, technology that are specially designed for military and intelligence applications, as well as fairly broad end-use and end-user restrictions that target exports when the U.S. exporter knows that the items will be used specifically for prohibited military applications or are destined to entities that are engaged in military activities and will use them for those purposes. But then starting in 2022, the US government has issued a series of very extensive export control regulations targeting the key building blocks and tools needed to develop and use AI. And so far, those have really been focused on advanced semiconductors, like the graphical processing units that NVIDIA produces, the GPUs, as well as the semiconductor manufacturing equipment, and series of restrictions related to supercomputers. And so the objective there has been to limit both exports of those items, the advanced semiconductors and supercomputers, to places like China, but also to limit exports of technology that would allow China and other adversaries to develop their own domestic capabilities. We are starting to see, a lot of discussion around how to address some of the remaining gaps. And so the realization has been that, with AI, you don't need to have your own computing systems. You don't need to buy the chips and the supercomputers. If you can use somebody else's computing power through cloud-based systems and data centers in other countries. And so the US government now is actively considering restrictions on cloud computing and provision of services that would support the development of large language models and other AI-related tools remotely.
Stephen, that's really helpful, and sounds like there's a lot going on, and I'm interested in understanding kind of where you think the future lies here, because it sounds like there is a lot of kind of proposals in the future. But maybe before getting into what the future looks like, Aline, I'm interested in your perspective too, how the UK and EU have approached export controls, and then in particular, how those rules are being applied to AI technologies.
Sure. And I think in a nutshell, the EU and its member states, its 27 member states, and the UK are lagging slightly behind the US on that question. We don't have neither in the EU nor in the UK specific proposal addressing export control that are specific to AI and AI technology at time of speaking. However, we do know and understand that both the EU and the UK are considering adopting common standards and control within their own jurisdictional sort of nexus. The difficulty that I think the regulators and the legislators are facing at the moment is how to maintain the level playing field between sort of trying to retain an economic competitiveness and addressing the potential national security concerns that are related to AI. And I think that's where both the EU and the UK are really trying to carefully strike that right balance between, sort of trying to have a framework that addresses the specific concerns without going too deep into the control so that it completely potentially, I don't want to use the word prevent, but at least impede or potentially create some obstacles for the development of the AI research and technology. It's worth noting that even under the current existing rules, you do have, just like in the US and similar to what Stephen was talking about, we do have in our own body of laws some specific aspect of the provisions that would, in any event, under export control laws, be relevant to the export or transfer or supply of a specific type of AI technology to non-EU and EU destination. The so-called catch-all controls are extremely relevant in that context. And for those who are not familiar with that concept, catch-all controls basically regulates a technology that is not in itself listed in what we call the dual-use export control list, i.e. the list of items and technology that are always subject to restrictions when being exported, but because of a potential end use, i.e. a military application or a weapon of mass destruction potential application, or because of an identity of a specific end user, would need to be vetted by government prior to their export out of the EU and the UK. So those catch-all controls are already in force here in the EU and the UK and would in any event apply to an AI sort of technology that would be used or potentially could be used for a prohibited end use. I think the issue at policy level on the EU and UK side is clearly to what extent the regulators would want to try to agree on sort of common standards with like-minded countries, which has generally been the case when we look at sort of developing export controls on dual-use technology under the so-called Wassenaar arrangement, which is the multilateral framework that countries have traditionally worked under to develop specific type of control entries. The issue with that framework is it's more and more difficult to agree with that number of countries that might not have the same national security concern as the US, the UK, and the EU would have. And obviously, Russia is a member of Wassenaar arrangements and over the past couple of years have been blocking specific type of controls that the UK and the EU and the US would have wanted to adopt in their export control laws, but was blocked by Russia. And as such, we are seeing a sort of a move away from trying to agree at that, sort of multilateral Wassenaar framework and trying to develop much more unilaterally some aspect of controls that would address emerging technology, national security concern related to semiconductor, to the building of supercomputer, to quantum technology as well. And that is clearly, I think, where we are going as well in terms of AI is the UK and the EU will look at the US, but also look at what it is that they want individually to be doing to control specific aspect of the technology.
And Aline, is it the same case where the focus currently is in China? I think Stephen had mentioned earlier that the US is perhaps dragging some of its allies along in connection with some of the policy-related decisions. Is the same focus that the US has kind of extending now into the UK and the EU, or is the focus more on Russia? I mean, how is you're seeing that play out with respect to AI?
It's a great question, Scott. I think when you see it in a non-US law context, we hear much more sort of that focus of China that perhaps you will hear, right, on your side of the word. Clearly, I mean, China is a national security concern in some aspect of technology and access to emerging technologies, but I think it's less it's featuring much less predominantly here. I think the concern on AI is really sort of regardless of a specific country, whether specific actors or specific end users are problematic in themselves, right, for AI. So clearly China is always there, but it is not as targeted, I would say, as what I hear it is on the US side. I think clearly the issue in regulating AI under sort of a new body of export control laws is also, trying to define what is AI in itself. And because the technology and develops at such a high speed, it's quite difficult for regulators themselves to come up with, sort of a definition. Obviously, we know that on the EU side, we have that very first sort of AI Act that came into force a few days ago. So the EU is slightly ahead in that specific respect. But clearly, it is going to be a challenge for export control laws where you have to define very precisely what it is, what characteristic, what parameters the laws will control on a specific technology. And secondly, I think the definition of what would constitute a misuse of AI is also a challenge, right? Because we are looking at so many different types of potential myriad of end applications that, again, regulators are facing a real challenge to address what it is that they would perceive as a national security risk, not only today, but also in the short, medium to long term.
Yeah, I mean, that's really interesting. I mean, in some ways, the definition of AI is very elusive, and it's difficult to kind of get your arms around it. And so trying to then dictate, what types of technology may be able to be exported subject to all of the considerations you're both describing can be very challenging for organizations. And that's overlay with the fact that, I think as we all know, and listeners of this podcast certainly know, is that AI is not new. Right. It's almost like, while we've been talking about it, and Stephen, I think you mentioned 2022 as, areas where the US government started to lean into this. In some ways, that's at least a decade too late from when, AI started to be pervasive. We just didn't focus on it in the same way. And perhaps we didn't have kind of the generative AI element that has been such the focus. So I'm just interested in maybe your perspectives are, if we are in the position where the software, the hardware, and the data that makes up the AI technology has been widespread and available for a long period of time, and now we're imposing these obligations really from the first time, that's got to create a real challenge for organizations to somehow adjust course based on the new national security threats that you both have been articulating.
Yeah, I mean, I think, Scott, to some extent that's true, but I think we are also seeing within the last couple of years very rapid advancements in large language models and computing power in particular. Advanced semiconductors have really advanced rapidly. And so I think, we are kind of entering into a new phase where the capabilities have, reaching new thresholds and creating the ability to achieve certain, military functions that weren't possible in the past. And so I think, there's several things going on here, but one is, as you mentioned, Scott, defining AIs has been elusive. One of the things that the U.S. government has, started to at least, considering is defining the technologies to be restricted on the basis of computing power. And there was an executive order that came out late last year proposing one definition of that, and I think the sense has been that the large language models haven't reached those capabilities yet, but are getting there. But I think the focus of proposed restrictions that additional rules that are being considered are really kind of taking two approaches that track the kind of the distinction between general use generative AI versus application specific AI. And so on the one hand, having very targeted restrictions on AI software and systems that are specially designed for particular applications, particularly military and intelligence applications, and then having a kind of looser set of notification or restrictions that licensing requirements that allow exports and transactions to go forward for legitimate commercial and civil end uses, while then allowing the government to have visibility into proposed transactions and prohibit those that they view as specifically for military applications or otherwise posing a threat to national security, foreign policy concerns.
Yeah, really interesting. Another maybe unique aspect that we see folks at least in the data community is that when regulators and legislators are thinking about the national security implications of AI, they're looking at, the hardware, the software, and then frankly, the data under which, that's driving all of those things. And, Stephen, as you well know, the executive order that came out from the Biden administration, surrounding the export of U.S. data was really a sea change in the way that U.S. policy has ever been set up, where we haven't had broad restrictions on the export of personal data to other countries in the same way that, Aline, you're well familiar with, that it's been longstanding principles that underpin EU and UK data protection law. But importantly, the US is now thinking about that export not as a consumer issue, not as an issue of trying to protect individuals from a privacy perspective in the way that I think the EU and UK do it, but instead kind of thinking about it from a national security perspective. And in particular, that, the idea that the personal data and that large volumes of data is really going to be needed to train those AI technologies, which then can be used to present these specific national security concerns. I mean, that's new and unique, and at least in my experience, has never really been the strategy, but maybe that is going to be the new future. Interested in both of your perspectives on that.
Yeah, that's a very interesting point, actually, Scott. And I think, sort of the parallel that you draw with GDPR here on the EU side is very interesting. And I think this is why when you look at sort of regulating AI from a regulator's perspective, they would say, well, sort of the enhancement of their ability to have this oversight through sort of the request and the requirement of licensing specific type of AI technology prior to them being exported is crucial, because that's how governments know what is being supplied, transferred, and exported out of their jurisdictions. So clearly, sort of the rationale for governments is there. Going back to your earlier point on sort of what that means from a client perspective and companies having to navigate sometimes conflicting type of framework. And we have seen that, right, in the context of GDPR and personal data and the interaction with sort of localization laws in specific countries and addressing transfer. I mean, that's where sort of in an export control world, historically, countries have tried to agree at Wassenaar level and argue for multilateral controls, right? Because if you have multilateral controls, i.e., some sort of common standards that like-minded countries and states have to adopt in their national law, well, sort of you address not only the competitiveness issue for specific governments, but also the fragmentation that companies will have to face when complying with those sets of laws. So, sort of unfortunately, what we are seeing now is because national security is very nationally driven, right? The US definition of national security might not and will not be the same as the UK definition of national security, and even within the EU, there is not an EU-wide definition of national security. There are 27 member states' notion of what national securities are. Clearly, I think when you look at sort of addressing AI misuses through export control, we will be looking more and more at unilateral controls, potentially some level of sort of parallel between the UK, EU, and the US, but still it is clear that differences are already there, right? I mean, in the US, you already have some pieces of legislations. We still don't have that in our laws. So I think clearly we are going to a path where, just like, as I said, for quantum controls, we are seeing sort of, those bodies of law developing nationally. That is the reality that I think our clients and company will have to live, both when they have to exchange R&D and technology relating to AI with counterparts from San Francisco to Paris, right? They will continue and potentially have to do that more and more in the context of all type of national security related export control in the short to medium term.
Yeah, really interesting. Stephen, I'm interested in your perspective. I mean, this is obviously a very fast moving and dynamic regulated space. Say we're doing this podcast in a year, 2 years, 3 years. Where do you think the future of this, of export controls and AI lies? And maybe starting from a US perspective.
Yeah, and Scott, this maybe comes back to your, I think, original question about the impact that the development of AI has had on export controls as a regulatory regime. And I think one of the things that we're seeing is a real expansion in sort of the scope of export controls, the specific tools that are being used, and also the legal authorities of the U.S. government agencies that are charged with regulating these technologies. And so, in particular, the Commerce Department's Bureau of Industry and Security is growing, expanding its staff. They have a new office focused on ITCS and ICTS, Information and Communication Technology and Services. And, the agency is really expanding beyond export controls to include import restrictions. And so, I think one great example of what we were just talking about are the, growing concerns and restrictions related to autonomous driving and connected vehicles, which of course are AI driven. And so, on the one hand, the government is developing these extensive export controls around the tools that are needed to develop artificial intelligence-based autonomous driving systems with the restrictions on the semiconductors and supercomputers. But then at the other end of the supply chain, the U.S. government is starting to develop restrictions on imports into the United States, particularly Chinese-made vehicles and software systems for autonomous driving, due to concerns about the ability of those systems to collect personal data of U.S. persons, and also sensitive location data that could be used in various forms of attacks on the United States and U.S. citizens. And so that's, I think, in terms of where we're going to be over the next 2 or 3 years, it's an really expanding web of restrictions around all of these issues and trying to really get at all aspects of this.
Yeah, Aline, what do you think from a UK and EU perspective?
Sure. Well, it's difficult to comment because we still don't know. We don't have any proposal. As I said, we are still lagging behind sort of the US initiatives on export control and AIs. But I think if I had to sort of look at the recommendation that we hear coming from governments here in the UK and in the EU, clearly, I think the focus is on regulating highly specific AI applications and technologies that have a clear dual use purposes, rather than having an approach that is much more sort of broad-based type of export controls. So clearly, I think that's where the policy intention is on the EU and UK side. There is a a clear focus in trying to engage in international dialogue with like-minded partners. And obviously the US is extremely important in that respect, to try to agree on some set of harmonization to the extent that it can be possible, and avoid unilateral actions that could harm both the EU and the UK's competitive edge. And lastly, and I think this is really something that's, you know, even outside of AI, in an export control world, governments here are really trying to address, is invest much more in robust enforcement mechanism, and regularly review the current controls that we have under our own existing body of export control lists to match the sort of technology, the advance and the advance in the technology that we are seeing. And really sort of the challenge for regulators is, how do you keep pace with the technological developments? And that is an issue that is obviously sort of focusing pretty heavily for AI, but that is sort of, you know, I would say relevant for all aspects of our export control lists.
Yeah. How do you keep track of the technology? And then maybe another question is, you know, how does the AI lawyer keep track of all the legal developments in this space? Because, you know, one of the challenges, maybe this is my last question for each of you, is that we've had the debate on this podcast about whether AI law is a separate legal discipline, or whether it's just really kind of a combination of a number of other disciplines that somebody's need to kind of pull into a single package. But I think there are many people who are now being asked to play the role of the lead AI-oriented lawyer within their organizations. And they may come from an IP background, they may come from a data background, a cyber background. You know, typically they've come from some legal discipline, and they have never been asked to know it all. And it seems as though now the challenge is that role needs to know at least a little about everything. And so maybe my last question for each of you is, you know, let's say you have a person who is in that role, and now they're being asked to issue spot across all of their areas of legal disciplines. What advice would you give them? What practice points would you give them about how to spot the export control issue in their day-to-day work?
Sure. I mean, you know, this is something that comes up regularly in our space, because the rules are so technical. And also, you know, it is so common that you have positions within companies that are, you know, broader and address, you know, a wider range of regulatory issues. You know, we find it's really only the kind of larger companies that have, you know, dedicated teams of export control personnel to address these issues. And so, you know, a lot of this and a lot of what we do, frankly, is, you know, providing awareness training to companies so that they know enough to issue spot and you know, when to raise concerns. And, you know, it's really, you know, in this space going to be, you know, just very much about, you know, knowing when to hit the pause button and go check as to whether, you know, the specific technology that you're exporting may be restricted, or the particular company that you're dealing with internationally is on one of the U.S. government restricted parties lists. You know, there just are a whole range of these kind of, you know, trigger points or choke points that the U.S. government is using to restrict particular transactions. And so, you know, but ultimately it comes to, you know, any time technology is, or, you know, hardware, software are flowing across international borders, there needs to be at least some level of check for export controls compliance.
Yeah, sounds like whenever you have a multinational deal, like it's probably a good idea to bring in your export and trade specialist to understand where the issues may lie. Aline, interested in your perspective, any other practice points you have for those people who are now newly being asked to spot these issues when they have never really had to do so in the past?
Sure, and it's a challenge, but I think you're using the right word. It's about spotting the issues, and then obviously sort of the specialist and the experts would come in. But I think it's also down to us, sort of more the experts who have been following the export control developments in this area for quite some time to also educate, right? To make sure that people and partners and clients we work with on a regular basis are, even if they are not, not being asked to actually do the analysis, would be able to spot that potentially a specific type of technology or an item may be falling under sort of the export control regimes, and as such would require a potential permit or license from a competent authorities. I think in our world, on the sort of the EU and UK side, it is even slightly more challenging than for you, because on the EU 27 side, obviously you are not looking at sort of one set of language, right, that applies. I mean, we are looking at 27 member states that then adopt laws in their own sort of national legislative framework. So it's not that you have the controls that are all in English available on one database. So we've been navigating, for instance, with various clients, sort of the controls that apply to semiconductor, to specific type of emerging technology. I mentioned quantum several times before, because all of those will be sort of adopted at national level, and as such in a different language every time. So, I mean, it is a challenge, right? And as I said, it will continue to be a challenge as we are seeing more regulation, potentially fragmenting the work that I found that the companies would be doing on the international level. But I guess that's where we are here as global trade lawyers, is really trying to help them anticipate, spot the issues, and also navigate the compliance challenges.
Yeah, I mean, that anticipation, I think, is probably a key, because there's so many innovations in this space, and that I think the businesses are moving very fast. And as you pointed out earlier, probably faster than the legislatures and the regulators in the area. But at the same time, it's likely that whenever the legislators and regulators do act, it's not only going to apply to what you do going forward, but all of the relationships that you may have already implemented. So as you're anticipating what the issues are, that is going to be key to make sure you're trekking with your trade teams early and often.
I think that's right. And I would say, Scott, if I may add something, is also, I mean, the regulators are really, I think, eager to hear from the industry. So it's not necessarily sort of anticipating the law, but also working with the respective governments to make sure that what they do also is reflective of what the industry is doing. There is that policy, I think, shaping exercise, especially for AI and export control, that is particularly important at the moment.
I think that is exactly right. And maybe that's where we leave today's episode. Aline, Stephen, thanks so much for joining the podcast. I feel like I've learned a lot, and I'm sure the audience has as well.
Thanks so much, Scott.
Thank you.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.